Hello, everyone. My name is Federico Tozzi. I'm the Executive Director of the Italy America Chamber of Commerce. Thank you very much for being here. First of all, I would like to thank our speakers today, Gina Piazza and Federica Rigato. They are both from one of our senior sustaining member, Tarter, Krinsky, and Drogin. We've been working with them for many, many years. They are very strong supporter of our organization, and they've been doing a tremendous job in, you know, talking about all these legal issues. They have an amazing practice here in New York, so I'm sure that you will find the webinar extremely interesting. It's just a part of a series. If you go to our website, you will see that there are others scheduled. I think all the topics that they're going to touch are very, very interesting. So I'm sure that you will find the event fantastic. So without further ado, I'm going to give the floor to them, but I will tell you that for any questions, please wait until the end. Write your questions in the chat, and they will be answered in the last 15 minutes of Q&A. So thank you, and I will let them start.
Thank you, Federico. Good morning, everyone, and welcome. Thank you for joining us today for this session on e-commerce compliance and risk management. My name is Gina Piazza, and I'm here together with my partner, Federica Rigato. We both work extensively with companies that are expanding or planning to expand into the United States, including in the retail space. Our role is to help businesses understand the legal framework governing commercial operations in the US and the practical implications of compliance from a business perspective. I presume that the reason many of you are here today is that you or your clients are already operating an e-commerce business or planning to do so. As cross-border commerce has grown exponentially, particularly over the past few years, so has the complexity of the regulatory environment. In 2025, e-commerce operators face a web of overlapping privacy, consumer protection, marketing, and accessibility regulations. Excuse me. Our goal in this webinar is not to provide legal advice, but to offer a broad overview of common legal and regulatory topics that businesses will encounter when entering or operating in the US e-commerce space. So we'll discuss the main recommended website policies for an e-commerce site targeting the US market, like privacy policy, terms of use. We'll touch upon the main compliance issues for an e-commerce site operating in the US market. So let's say privacy and accessibility. And we'll also explore how to promote the brand while respecting consumer protection laws and commercial and advertising compliance regulations. Think CAN-SPAM and the FTC Act. So we'll provide real-life examples and industry cases to give you a sense of how these issues appear in practice and how businesses respond to them. And at the end of the session, like Federico said, we will answer some of the questions that you might have. So I'll turn it over to Federica to start the conversation with website policies.
Thank you, Gina. Good morning, everyone. As Gina mentioned, I'll start with a brief overview of website policies that we typically recommend retailers entering the US market or operating in the US market adopt on their platforms. These will obviously vary based on industry, on the business's needs, but in general, these are examples of the minimum policies that we would recommend be implemented. So in case you're selling products, terms and conditions of sale and return policies, which is typically ancillary to the terms and conditions of sale, terms of use, regulating the website itself, and privacy policy to govern collection of personal information. The contents of the policies will vary also, again, based on industry and the actual business practices of the company, and I will go over them in detail in a minute. But just in general, the key point to keep in mind here is to be transparent and to give notice of your practices to consumers. Essentially, think of these policies as sort of a contract between the company and the consumer. So the consumer needs to know what they are agreeing to, what the terms of their relationship are going to be. To accomplish this, it's important that all the terms are disclosed in advance of any transaction or interaction with the user. So for example, although it's not mandated by law, our suggestion in terms of best practices, it's always to allow the users to review the terms before agreeing to them. So for example, if possible, having a scroll through where the user has to read, or at least is given an opportunity to read the terms before agreeing to them. We understand that this is not always practical. So alternatively, what we suggest is having a checkbox where the user performs an affirmative action. So again, checking a box, clicking a button, saying I agree, with a statement such as by clicking this button, by checking this box, you're agreeing to the terms of sale, terms of use, privacy policy, with links to each of those policies so that they have an opportunity to read the terms if they wish to do so. In addition to this, obviously, the policies should always be available on the website's homepage. If there are changes that are substantial to the policy, we recommend, for example, sending an email to users, especially in the privacy space. This is very important if you're changing any data collection practices. In certain cases, you might need to get consent, but at a minimum, you should notify if your terms are changing in a substantial way. And in addition to having them on the homepage, again, we usually recommend that users agree to the terms upon making key actions. For example, terms of sale, they should be agreed upon at checkout. So before checking out, there should be a checkbox saying by placing an order, you agree to our terms of sale. Privacy policy, if you're subscribing to the newsletter, there should always be a link to the privacy policy. And account creation, same. Both terms of use and privacy policy should be linked. And this is obviously with a view to ensuring that these policies are enforceable should there be an issue with the customer down the line. The first policy I'm going to go over is the terms and conditions of sale. So again, this would apply to sale of products. The content will vary. There's usually a lot of freedom as to the contents that can be set forth in the policies. Typically, these will address order placement, shipping. So for example, you always want to make sure that you provide that shipping timeframes are estimates. They're not binding on the company. Payment terms, if you're using a payment processor, a third party, which most websites are these days, you should disclose it. And also product warranties or disclaimers to those warranties will be regulated in the terms of sale. So there are certain industries where you have to provide certain warranties. For example, in the food area, there may be warranties you need to provide, or in the health area. But for other typical consumer goods, let's say apparel, unlike other jurisdictions such as Europe, you don't necessarily need to provide a warranty on your product. But again, here the key is being transparent and disclosing these terms. So if you're disclaiming warranties, this needs to be clear. So if you're selling your products as is, and you're disclaiming the warranty of merchantability, for example, this needs to be clearly disclosed in your terms. So we always recommend it be, for example, in all caps, in bold if needed, to ensure that this is clear and there is no misunderstanding with the consumer. Again, you're typically free to set your terms. There might be certain state or federal laws that provide for certain consumer protections that apply. For example, for online sales, there is an FTC rule that provides that to make a shipment statement, there needs to be a reasonable basis to do so. So for example, if your terms say we usually ship between 2 and 3 business days, there needs to be a reasonable basis for you to make this representation. If you don't say anything, you should ship your products within 30 days. And if you're delayed in shipping products under certain circumstances, you need to notify the customer and offer them the opportunity to either accept the new shipment timeframe or cancel their order and obtain a refund of any price that has been paid if it's already been charged, for example, to their credit card. A corollary of the terms of sale is the return policy. which obviously addresses returns in the US. Again, there may be exceptions based on industry, but typically you're not required to offer a refund or an exchange. This can vary state by state. So as an e-commerce platform, obviously, unless you're geofencing your website for any specific reason, you will be accessible from all 50 states. So you need to ensure that you're complying with the jurisdictions where you're offering your products for sale. So before putting any limitations to your return policy, you should make sure that it's compliant with the law of the 50 states if you're offering your products nationwide, which is the case in most cases. Again, here, transparency and disclosure is the key. So if you choose to not accept returns at all or limit them, for example, you have certain products that are a final sale, you only issue a refund in the form of store credit and not cash, all of this needs to be disclosed before the purchase is completed. So if I place an order and I then receive a confirmation email and the confirmation email says there are no refunds, then that's not compliant because I did not have an opportunity to be aware of this before I placed my order. So obviously this needs to be disclosed in the return policy. Again, we would suggest linking the return policy to the checkout page as well. But also in the online world, our recommendation would be to put a disclaimer on the product page itself in bold, in caps, that says no returns, final sale, or equivalent language so that the consumer knows before placing the order that that product cannot be returned. Again, I'm putting a lot of emphasis on disclaiming because if these limitations or exclusions are not disclaimed properly in certain states, you would need to still offer a refund with proof of purchase within a certain time frame. So if I'm not letting you know properly that you cannot return your product, I'm still going to have to accept a return to your product. The next policy I'm going to discuss is terms of use. These are typically terms that essentially govern interactions between users and the website. So they will govern account creation, for example, eligibility. For example, we always suggest including language that limits use of the website and any transactions happening on the websites to users that are 18 or older. This is to avoid the application of certain laws at a state level or federal level that apply to minors that could have to do with privacy issues or posting content. For example, in California, if a minor can post content, there are certain additional rules that apply. So in order to avoid a host of issues at a state level and federal level, we would include in the terms of use that only users 18 or older can use the website. Another aspect that's usually regulated in the terms of use is intellectual property rights. So for example, you want to make sure that it's clear in the terms that any trademarks, logos, names, trade names, but also any patents, if any designs used by the website or the platform are property of the website operator or its affiliates. And the license given to the users is very limited, just for the purpose of using the website, of navigating the website, and that the same cannot be copied, they cannot be used. So this is something where you would protect your IP. On this note, an important federal law to note is the DMCA, Digital Millennium Copyright Act, which has to do with copyright infringement. For website operators, this is important if you're allowing third parties to post content on your website. This obviously, a prime example would be social media platforms where you can post pictures, but also for retailers, this could come into play if, for example, you're allowing your customers to post reviews with pictures. So anytime anyone that is not the website operator can upload content on your platform, this is important because this law provides for certain limitations to liability of the website operator for copyright infringement claims if you put into place certain measures. So this would be primarily the appointment of a DMCA agent. Basically, you would need to appoint a person that is demanded to receive any copyright infringement notices on behalf of the company. This would be disclosed in terms of use. So you would say, if you believe your copyright has been infringed by any content on the website, this is our DMCA agent, this is who you need to contact. It is not sufficient to just put it on the terms of use. You also have to register your DMCA agent with the Copyright Office. The DMCA agent can be your legal counsel. It does not have to be your legal counsel. It can also be someone internal to the organization, as long as it's someone that will then escalate to the appropriate person, which can be internal legal counsel or outside counsel, these copyright infringement notices, so that they can be addressed properly and timely. The main aspect I'll focus on today, as Gina mentioned, from a website policy perspective, is privacy. It's a really hot topic these days. Obviously the privacy policy is the policy that governs the collection and processing of personal data. It can, typically a retailer will collect a number of information such as names, addresses, email, phone number, but also payment information. Unless it's using a third-party provider, then they might not collect it directly. Purchase history, and so on. But obviously these days, virtually every website is also collecting information automatically, such as through cookies and other tracking technologies. So even if you just have a landing page, even if you're just starting out and you're not, for example, you don't accept user process transactions on your website, if you're using cookies, you're still collecting personal information. So this is something you need to be very careful about. And, until less than 10 years ago in the US, there wasn't a lot of regulation in the privacy space, other than a few exceptions, such as California, which has always been the most consumer protective state. Typically, retailers could essentially do whatever they wanted with the personal information that they collected from the customers, as long as they disclosed it. And even then, not all states, or I should say a very small minority of states, require that a privacy policy be posted. So compared to Europe, there was a lot more freedom in the privacy space in the US. That is changing a lot, as I'll discuss in a minute. So privacy is definitely one of the topics that you want to be paying careful attention to when you're setting up a website in the US. And because the law is evolving so much, you should always review periodically your privacy policies and your privacy practices to make sure that they're still in compliance with law. So I'll go over some privacy risk areas. First of all, as I mentioned, the landscape in the US is different from what it was, and it's different from other jurisdictions such as Europe. There isn't a comprehensive federal law that addresses all privacy areas like GDPR would be the equivalent of in Europe. There are some sector-specific federal laws, for example, for medical data, financial data, education data, data of minors online, but not just applicable to all businesses across the board. As I mentioned, the state law landscape is changing. California was the first to adopt a comprehensive privacy law. The CCPA was adopted in 2018 and went into effect in 2020 with amendments later on, and it's being amended constantly. There's new regulations coming out. New regulations came out a month ago to address other issues that were not in the original regulations. And on this trend, a number of states now, we're at almost 20 states having adopted laws or having bills pending to govern privacy on a broader spectrum, not just on a sector basis. Because, as I mentioned, an e-commerce platform will likely be accessible from all states, you need to, a retailer entering the market or already operating in the market needs to assess what state laws may apply to the company. Because unlike, for example, GDPR, it doesn't just apply to every company doing business in the US or in the specific states. There are typically thresholds that need to be evaluated. These thresholds may vary based on the states. For example, it can be based on annual revenue. Prime example, the CCPA in California. If your annual revenues are above $25 million, which has been adjusted for inflation, so now it's 26 and change, but around 25 million, then CCPA will apply to you. And the way business is defined is not just the US company, but it might also include companies in the same group if they're under the same trademark and are sharing information, which is usually the case for our clients. So you should look at group revenues. In other states, or also in California, if you don't meet the revenue threshold, whether the statute applies can also depend on the number of consumers in that state from which you're collecting personal information. So, for example, 100,000 Virginia consumers. Another threshold that's important is even if you're not meeting the revenue thresholds, there may be different thresholds based on the type of information you're collecting. So if you're collecting sensitive information, or if you're doing certain types of processing, such as selling information, those laws may still apply to you, even if you don't otherwise meet thresholds. So this is something you need to do a data mapping, and you need to understand what your customer basis is, what type of information you're collecting, and from what states. Because, as you probably already know, the US is a very litigious country. In drafting a privacy policy and in implementing a privacy compliance program, it's not sufficient to just look at the legislation, but it's also important to be aware of case law. So I thought it would be useful to point out certain litigation trends that we're seeing recently, because they're shaping how companies are shaping their privacy practices. The primary one, which I'll go over into greater detail, is the California Invasion of Privacy Act, which is a law from the 60s that was meant to apply to phone interceptions mostly, so eavesdropping, wiretapping, and it's now being used to sue websites alleging that certain digital tools used by those websites are interceptions of communications. This is because there are these plaintiff side law firms that are essentially suing websites to try to reach settlement agreements and receive a settlement payment by interpreting these laws that were not meant to apply to the digital world, because obviously in the 60s, nobody could have predicted what cookies would have been. But they're kind of bending the law to make it apply to their intended target. Similarly, in Florida, we're seeing trespass cases being brought against companies alleging that placing cookies without consent is a trespass. The last one I'll briefly mention, not related to cookies, but also relevant. It's the Biometric Information Privacy Act of Illinois, which requires consent for a collection of biometric data. Biometric data is not something that potentially a retailer would think applies to them, but we are seeing makeup companies, for example, being sued for use of the so-called virtual try-on tools. So those tools that essentially analyze your face shape, your face geometry, for you to try on makeup virtually. If they do that without consent, these plaintiffs are alleging this is in violation of BIPA. So they're also seeking settlements. For example, Sephora was one of the companies that was hit with this lawsuit, and they had to pay a substantial settlement amount. As I mentioned, I'll focus mostly on California Invasion of Privacy Act. As I said, most websites use cookies, so this is a relevant one to point out. It governs interception or recording of electronic communications without consent of all parties involved. California is a two-party consent state, meaning both parties to a communication need to consent to recording. And again, this has been applied in the e-commerce world for digital tracking tools that are operated by third parties. So what could be some practices that fall under the statute? Use of session replay technology without knowledge and consent. For example, if a website is analyzing how you interact with its pages, so how you're clicking, scrolling, and typing, to then serve advertisements to you that are targeted to your interests, and that information is being shared with third parties, that is considered by these plaintiffs an interception of communication. Cookies, as I mentioned, same thing, third-party cookies, the information is being shared with other advertisers, for example, Meta, and I'm not aware as a user that my information is being shared, and this is considered a communication. Another example that we're seeing in litigation is live chats. So those typical customer service live chats, if they're operated by a third-party operator and they have access to those conversations without consent, that's also considered an interception of a communication. How can a SIPA claim be avoided? Again, key here is notice and consent. So having banners that indicate that the monitoring or the recording is happening. Cookie banners are very important. I'll show you some examples in a moment. For session replay technology, again, having consent, explaining that the tracking is happening and that information may be shared with a third party. But also it's really important for compliance also with other laws, for example, CCPA, that if you use a third-party provider, there are specific agreements, such as a data processing agreement, that include obligations for the processor. So, for example, certain safety measures, or that they cannot combine the information provided for other purposes. They cannot share the information. They can only use it for purposes of providing the service. That's also very important. So there should be an audit of your agreements with those third parties, and they should always be reviewed by legal counsel to make sure that you're compliant with your obligations. As I mentioned, I'll show you some examples of cookies. Again, the majority of these litigations that we're seeing under SIPA are usually aimed at cookie banners. Virtually every website you're visiting these days has a cookie banner, but a lot of them are not compliant. The first example I'll show you, you can possibly immediately tell it's not compliant because it only gives you the option of saying got it, accept it. That's not compliant because it's not a true choice. It's not really asking for my consent. It's forcing a choice on me. So that would not be considered compliant for SIPA purposes. The second option at a first glance might look a little bit better because it does have the accept option and another option. But if you see, the other option is a customized option. So there isn't a reject option. Under CCPA, if it does apply to the business, cookie banners are not required per se, but the CCPA as a general principle provides that if you offer a choice, the most privacy protective choice cannot be harder to achieve than the least privacy protective choice. So me rejecting cookies, which is more protective of my privacy, cannot be more complicated than accepting them. So if to accept cookies, I have to click one button, but if to reject them, I have to click 3, that's not symmetrical. That's not going to be compliant with CCPA. This example is a good example of a compliant cookie banner. As you see, it has the accept and the reject option. There is also a manage cookie option, but that is fine as long as you have the two symmetrical choices. You can also give an option to customize. And also, as you will see, it doesn't say accept all or reject all. It uses the optional cookies terminology. And the reason is that there is yet another litigation trend alleging that using reject all is actually misleading because there are certain cookies that are necessary to operate the website and cannot actually be rejected by the user. Therefore, saying reject all doesn't actually inform the user about the fact that certain cookies will necessarily be placed on their browser. So the suggested language is accept or reject optional cookie or not essential cookies to indicate that certain cookies will inevitably be placed on the browser because that's what is needed for the website to operate. And with that, I'll give it to Gina to discuss accessibility issues and other issues.
Thank you, Federica. So with respect to websites, aside from the terms and conditions and other policies that are required, there are some other risk areas that we would like you to be aware of. So the first one is website accessibility. and ADA compliant. So many of you who are operating, or if you know someone who is operating a website, you've heard about someone who's been sued because their website isn't compliant with the ADA. The ADA was passed in 1990, and it was meant to apply to physical spaces and allow equal access for individuals with disabilities to those physical spaces. Over the past decade, that law has been expanded to apply to digital environments, requiring that websites, e-commerce platforms, mobile apps also be accessible. The objective really is to ensure that all web users, including those with disabilities, can access and use e-commerce sites. So what makes a website inaccessible? So the first thing is missing alternative text for images. So if the alt text, sometimes called the alt text, isn't included in the background of the website, the screen reader won't be able to read on behalf of a visually impaired person and to tell them what actually is on the website. So to describe, the content. Poor keyboard navigability. So essentially, a visually impaired person might use their keyboard instead of the mouse to operate their computer and browse websites. If the screen reader or the other programs do not interface correctly, unfortunately, the visually impaired user will not be able to navigate the website. Low color contrast or insufficient color contrast between text and background. This basically means that the background is too close to the color. The background color is too close to the color of the text. And people with low vision or color blindness might struggle to distinguish the content. So they'll have a really hard time reading the content. Lack of captions or transcripts for videos. So if you place a video on your website, those videos must have closed captions or something else to help individuals with a disability to understand what's going on in the video. And lastly, just basic screen readers are incompatible with the website. So the website isn't letting these screen reader tools in, which creates almost an instant block to being able to use the website for individuals with disabilities. So what's been happening in the legal landscape here is that we have a lot of repeat plaintiffs and repeat lawsuits. Courts are interpreting the ADA to apply to private businesses online. There used to be a correlation where there had to be a physical location in order for the ADA to apply to a website. That's pretty much been removed. And while we over time have thought that these lawsuits would fade out, there's been a recent surge in these lawsuits, and 2,000 ADA website accessibility websites were filed in the first half of 2005, and then the projections are that they will exceed 5,000 total filings by the end of the year. So again, it's a persistent trend. It involves serial plaintiffs, so it's the same plaintiff filing hundreds of lawsuits. The plaintiff firms filing the lawsuits are often targeting businesses in hospitality and retail. We've handled hundreds of these cases, and we often see the same plaintiffs with the same law firms suing unrelated clients. So we've been across the table from these law firms and plaintiffs on behalf of many of our clients. I should also note that while there is case law, it is limited because the majority of the cases tend to settle either pre-trial or pre-filing. So sometimes you'll receive a simple demand letter, and at other times you'll receive, of course, a complaint that's been filed against the company. Most of our clients, I think we've yet to litigate one of these. Most of our clients have chosen to settle the lawsuits because they can gauge where it's going to settle and how much they're going to spend. So rather than spending a lot of costs on the litigation and actually taking on the risk because they don't know where it'll land. They've chosen to settle these cases, and in recent years we've settled cases probably between $5,000 and $20,000, but it really depends on the plaintiff's lawyer. We've actually had some cases where plaintiff's lawyers have asked for product, gift certificates, and other things in lieu of cash when negotiating their settlement agreements. So how do we avoid these? What are the guidelines and best practices to ensure that our websites are accessible to individuals with a disability? So first, the standard set of rules that we're following is the WCAG, or the Web Content Accessibility Guidelines, and that's 2.1 level AA. These are currently considered the standard for website accessibility, and they address text, contrast, alt text, structure, navigation, and similar issues. The other thing that we're suggesting that clients do is conducting regular audits. So there is software out there that's available to you that could run an audit on your website. Generally speaking, the software that runs the audit is not sufficient. And really, in order to understand if there are any holes or there are other accessibility issues, you really have to do a manual audit. And when we talk about manual audits, it involves a person physically scrolling through your entire website to see if there are any issues. We like to suggest that actual individuals with disabilities provide these services to you. There are people out there. There are also national organizations for the blind, for example, that offer these services to third parties. And the reason is because they are the users and they would likely catch any errors related to inability to access the site. When you are working with providers, someone may tell you, sure, I can build your website. You need to ask them if they are familiar with the accessibility guidelines, with WCAG, with bringing websites into compliance, because a lot of our clients have simply put in a plugin or a widget that they think will solve this issue. And unfortunately, these widgets cannot guarantee ADA or WCAG compliance. So your web provider really needs to be specialized in this and know the area. The widgets also pose a significant risk because a lot of the plaintiffs' firms know that the widgets don't work and won't bring the website into compliance. So essentially, before they run all their tests, which they do on these websites, they see the widget there and they almost know that you're a ripe target for litigation. We've had clients that were shocked when they received a lawsuit or a demand letter after having worked with some of these companies that do put the widgets up. They truly believed that the widget would help them, and it generally wasn't the case. It was quite the opposite. So okay. So one of the next issues is CAN-SPAM Act. So what does the CAN-SPAM Act deal with? The CAN-SPAM Act deals with commercial email practices. And a commercial email a commercial email message is not just a bulk email blast. It covers both B2C and B2B. And commercial messages are anything the primary concern of which is to promote a product or service. So think an email from Gucci telling you to check out their new collection. That's a prime example of a commercial email. Transactional or relationship-based emails like order confirmations. So Gucci sends you an email saying, we got your order, your new bag is on the way, or shipping updates. Those aren't considered commercial emails and they wouldn't be covered by the CAN-SPAM Act. What does the CAN-SPAM Act do? One of the main features of the law is to prevent, is to provide an opt-out mechanism. So you can opt out of receiving future commercial messages. And business who fail to comply with the request to opt out face penalties of up to $53,000 per email violation. So this means that they can be potentially exposed to that number multiplied by the number of recipients of the offending email. So if they are not careful, they can have millions of dollars in penalties. In 2024, the Justice Department and the FTC entered into a settlement agreement with a company called Rigato. It's a cloud-based security company, and they required them to pay $2.95 million in civil penalties for failure to comply with CAN-SPAM. Some of the core compliance or the key requirements of the CAN-SPAM Act is to clearly identify who the sender is and the promotional nature of the message. There also needs to be a presence of an easy-to-use unsubscribe link. The opt-out request, as I said before, must be processed within 10 business days of the request. And subject lines must accurately reflect the message's content. And you also must provide a physical mailing address for the business in your email correspondence. And this can be a business office, a registered agent, or PO box. It's really important here to monitor third-party vendors. A lot of companies hire third-party vendors to send out these mass email campaigns. And you should have clear provisions in those contracts to determine who's liable for these violations. Of course, as the receiver of the services, you should be indemnified from the provider, but ultimately you always remain on the hook because you're the one sending, your business is the one sending the email correspondence. Another area that we see often with websites are sweepstakes. So you're looking to engage your user base, and you might think about doing that through a sweepstakes. So in the US, we have the concept of lottery, which involves a prize, an element of chance, so an element of randomness or a drawing, and consideration. So generally speaking, a payment. We don't want to fall into the category of an illegal lottery when we're setting up sweepstakes. So we need to eliminate one of these elements. Again, generally speaking, we eliminate the element of consideration because there's always a prize and there's always a drawing or something like a drawing involved in this. So the easiest thing to eliminate is consideration. Consideration could be considered present, where you're asking a client to make a purchase in order to be involved in the sweepstakes, or they have to make an effort. So they're trying on a piece of clothing, they're test driving a car, or they're posting on social media. We have some states. So when we eliminate the consideration, we either eliminate the payment obligation. So we'll always recommend to our clients that there is not a purchase required to participate in a sweepstakes. And we always, remind our clients that the effort involved has to be minimal. So sometimes it's a like on social media, sometimes it's a share, things like that. But we always also recommend that we add a free alternative method of participation, like sending an email or sending in a mail-in, because at least that way, if we haven't eliminated the consideration because we've asked the client to do something or to pay for something, which again, we like to prefer, we eliminate it by offering that free method of entry. So it's sort of buried in the terms and conditions of the official rules of the sweepstakes, but it's there and it's helpful. So The rules do vary from state to state. Some states require registration and bonding. Two examples are New York and Florida, which require registration if the total prize value is in excess of $5,000, and Rhode Island requires registration for prizes exceeding $500. Sponsors generally have to file in advance. So if you're planning a sweepstakes, you shouldn't come to us or your lawyer or whomever is operating your sweepstakes the day before and tell them that you have, a dream trip to Italy planned that cost in excess of $10,000, unless you're willing to exclude residents of New York, Florida, and Long Island, because again, those require some advanced planning, and at least 30 days in New York, and I think it's 7 days in Florida. So we do have then a set of official rules that we recommend be implemented when operating a sweepstakes. And the official rules serve as a binding contract, and they govern the operation of the sweepstakes. They include eligibility requirements, so age, residency, elimination of employees, also elimination of individuals in states that might have these registration requirements and you haven't registered in those states. It includes the duration, the entry methods. So some of the famous lines in the official rules are no purchase necessary. It includes also prize descriptions, how we're selecting the winners, and then it does also discuss some liability limitation clauses and publicity terms for the promotion of the contest once the winner has been announced. So really you need to think about careful planning around registration deadlines, eligibility requirements, and the disclosures that have to be made to ensure that the promotion engages customers legally and it avoids a classification as an illegal lottery. So with websites often come e-gift cards. There are federal and state laws that govern the issuance and use of gift cards. So these are not just e-gift cards, they're also gift cards for physical stores. But because an e-commerce website does touch 50 states, it's a little bit harder to manage, let's say, the competing requirements of each state when you're operating a website and issuing gift cards from a website. So under the federal law, gift cards and similar stored value products cannot have an expiration date of less than 5 years. And the law also regulates inactivity and service fees, which can only be charged after 12 months of the card being dormant. And then we have the state laws, which, states are permitted to impose stricter regulations, and many do. One good example is California. So California prohibits expiration dates on gift cards altogether. And then there are other states like New York, for example, that allow for shorter periods. New York has just changed theirs to 7 years. For e-commerce businesses selling nationwide, trying to track 50 different state rules is administratively impossible. It's a burden and it's time consuming and costly. So the safest strategy generally is to adopt the most restrictive standards. So if you're selling online, you might want to look at the laws of California so that you don't impose these expiration dates. The problem lies in the next slide, which is unclaimed property. So some businesses do not know that unused gift card balances represent a liability on the user's balance, on the issuer's balance sheet. In many states, these unredeemed balances are treated as abandoned or unclaimed property after a specified dormancy period. So New York, the dormancy period, for example, is 5 years. So if you have a gift card and you haven't used it for 5 years, that property should be turned over to the state of New York. I'm simplifying this so we can talk more about it offline if necessary, but that property, if the issuer, let's say the issuer is a New York company and the holder of the card is a New York resident, that property should be turned over to New York State. Each of the state's rules differ. Most states require annual reporting of unclaimed property, and they also have voluntary disclosure and compliance programs, which allow issuers to mitigate penalties and interest for late filings, because this is a requirement. You are required on an annual basis to report unclaimed funds. Because people are, or companies are unaware of these laws, some of them don't do this. We worked with a major retail client who was audited several years ago by the New York State Comptroller, and that experience led the company to join New York's voluntary compliance program and then expand its review of its unclaimed fund policies on a nationwide basis. So again, there are different dormancy periods, there are different exemptions, and there are different activities that might take the property outside of the unclaimed property classification. So you should talk to a professional who knows about this to discuss your potential liability for unclaimed funds if you do issue gift certificates. I think I covered that slide. So really the next slide covers truth in advertising. So the FTC Act, I'm just going to go really fast because we're running out of time here, but the FTC Act prohibits deceptive or unfair advertising practices. So disclosures in your advertising must be truthful and they cannot omit material information. I'll just give you a few examples of advertisements that were deemed deceptive in the past. So ExxonMobil, for example, advertised for years that its plastics were recyclable, while knowing that they actually weren't. So there were documents uncovered in a California lawsuit that revealed that the company had long understood that less than 10% of plastic in general could be realistically recycled, and it still poured millions of dollars into this PR campaign. Kering also faced similar class action lawsuits for labeling its single-use cups recyclable, even though they were aware that most municipal recycling programs couldn't process them. I would bring your attention to the use of words like clean, fresh, natural, organic. Organic has specific legal meanings under the USDA's National Organic Program, but other of those words like clean and natural, they're far less regulated and should be used with caution. There are some state laws that also come into play that will affect your operation of your website as well. One of those laws, I'll just give you a quick example, but that is California Proposition 65. If you do not know what Prop 65 is, and you've traveled to California, you've likely seen a product on a shelf in a store that says, warning, this product may contain lead, which is a known carcinogen, for example. So that's a requirement of Proposition 65. The state maintains a list of about 900 chemicals. They update it annually, and that includes the acceptable limits for each of those chemicals. And if your product exceeds those limits, you are required to include a warning on the product. For an online store, you're not only required to include the warning on the product, but you're also required to include the warning on the product display page or via a clearly marked hyperlink labeled warning, and that links directly to the full text. It cannot be buried in the description of the products, and the online warnings must be visible before checkout to satisfy the law. Some of our clients have attempted to limit the exposure to non-California residents by displaying the Prop 65 warning only when a user enters a California shipping zip code, or they include a pop-up or hyperlink during checkout before completing the sale. So there's a number of ways that you can limit the exposure to non-California users, because it might be a bit shocking for someone that is not in California and isn't used to seeing these on a daily basis. I think Californians have become pretty numb to these warnings. And a lot of times, companies don't even realize that their products contain these chemicals. We actually had a client who purchased and resold fashion items, and they had one single belt that was sold in the state of California, and it happened to be purchased by the state enforcement agency for Prop 65. The agency tested the belt, detected lead levels above the allowable limits, and determined that both the product and website should have carried a Prop 65 warning. In that case, we settled, but this does happen often, and we deal with them almost on a daily basis. Just one last note is that these the Prop 65 laws is just one example of a pre-purchase label. You really do have to look at this on a 50-state basis. So knowing your product, knowing what you're selling, knowing what's going into the product, and knowing what the local state requirements are, because again, you're a website, you're touching 50 states, and while you may not intend to do business in that state, unfortunately or fortunately, however you look at it, you are doing business in 50 different jurisdictions. So it's really important to know what the requirements are before shipping products into a state. So I'm going to stop there so that I can let you guys ask questions if you have any. Sorry for the rushed ending of the presentation, but we are, aside from being available now to answer some questions, we can take 15 minutes for those of you who can stay a little bit longer. We are available also by email. You can easily find us on our firm website. Thank you all.
Any question? There is a question in the chat. Let me check. So I see a question here is, which are some claims regarding to wellness that we must avoid?
There are some, I hope that I'm answering this. That's a little bit of a generic question, but I hope I'm answering this correctly. Of late, there are a number of recycling rules that put the obligation on the seller of packaging, the seller of products to assist with the recycling of the packaging of the products. So that's one law that I can think of. So you should be aware of any product packaging recycling requirements if you're selling product. Generally, most products have packaging. And another one is the PFAS laws that have been recently put into place. So PFAS are forever chemicals, and they cannot be included in food packaging and in certain products. Now, again, these vary on a state-by-state basis. So it depends on what your product is, what you're selling. We need more information to give you a more specific answer. But those are two general rules that have come up of late. Federica, do you have any other examples?
No,
Yeah,
there's a third one. No. This is just people that are, thanking you for for your seminar. So I think I don't see anything else. Yes. So, well, thank you both. Thank you, Federica. Thank you, Gina. I think it was very interesting. And so see you all at the next appointment. So we have other webinar scheduled with you guys. So I think everybody looks forward to meeting you again in the virtual world. So, and possibly in person.
Thank you.
Thank you.
Thank you. Bye-bye.